The meeting of the Judiciary and Public Safety Committee for Wednesday, March 18th, 2026 will come to order. We do have a quorum, and we'll begin with Senator Duckworth, your bill, Senate File 3338. Senator Duckworth, welcome to the committee, and tell us about your bill.
Thank you, Madam Chair. I appreciate the opportunity. I would first like to thank my co-author. As members can see, I was scraping the bottom of the barrel to get people to sign on to this one with me. I can make that joke because he's not here today, but I promise to be brief. So I see how it is. Unfortunately, the theft of gift cards in many of our retail places of business has become a pervasive issue. And you'll hear from some folks in just a minute, Madam Chair, about why it's an issue. And what this bill would seek to do is allow for folks who are doing this and doing it at a great scale to actually face some penalties or repercussions for that, what would be an illegal or criminal activity. So if that's okay with you, Madam Chair, I'd love to invite some testifiers up here to speak to the bill, please.
Yes, you may. I have Bruce Newstead and Josh Percola on my list. Mr. Newstead, please introduce yourself and begin your testimony.
Thank you, Madam Chair. My name is Bruce Newstead with the Minnesota Retailers. I work with retailers across the state in most of our communities. First off, I want to thank Senator Duckworth and Senator Latz for their leadership on the Senate file. The support is encouraging to the retail industry and deeply appreciated. I'm going to start with just being really clear, though, about what this bill does and what it does not do. This bill does not address the type of fraud where a scammer calls someone and convinces them to go buy an iTunes card. I realize I just dated myself with iTunes card to pay a fake bill. That's not what this bill addresses. That is a serious issue, but that's not this bill. What this bill targets is organized, sophisticated criminal activity happening at retail stores across Minnesota. Criminal networks are stealing unloaded gift cards off of store racks. They tamper with the packaging to capture the card number and the PIN, and then they return those cards to the store shelves. From there, they use technology to monitor when the card is purchased and activated or loaded with value, sometimes within minutes, and immediately drain the value of the card. Often, neither the consumer nor the retailer realize what has happened until well after the transaction. The harm is real, customers lose money, retailers absorb costs, and trust in the marketplace is eroded. Under current Minnesota law, if law enforcement stops someone with hundreds of compromised gift cards in their trunk, the charge is often only tied to the value of the plastic instead, because the card's worth has not yet been added in value. That does not reflect the reality of what's happening today, and these are not isolated incidents, and they're coordinated enterprise theft level operations. Now, I want to be clear, retailers are not sitting here today and standing still on this issue. If this were a problem that we could solve in the store on our own, we wouldn't be here asking you for help today. But the reality is retailers are continuing to invest in solutions. We're working in partnerships with law enforcement. We're training employees to spot tampering. We're educating consumers. We're advancing new technology and innovation and security measures to try to stay ahead of the schemes that exist today. But this is a criminal enterprise problem, and it requires the right statutory tools to match really the sophistication of the crime that happens today. Senate File 3338 fixes that gap. The bill wisely incorporates gift card fraud into Minnesota's organized retail crime framework that this committee and the legislature approved back in 2023. That law was designed specifically to distinguish between petty theft and true coordinated criminal theft in enterprises. It's what the statute calls a retail theft enterprise, and thanks to the chair and many on the committee, they were very intentional in picking that retail theft enterprise definition to differentiate from shoplifting and other crimes. By placing gift card fraud within that framework, you're not broadening enforcement indiscriminately. You're actually targeting the right actors, organized criminal networks operating with clear intent and sophistication. This bill gives law enforcement the clarity and the tools they need to investigate and prosecute these cases appropriately, and we appreciate your time and consideration of the bill today. You're going to hear from Detective Josh Percola from the Coon Rapids Police Department. He's also a vice president of the Minnesota Organized Retail Crime Association, and he'll walk us through why the statutory change is important from a law enforcement and case development perspective.
Thank you very much. Mr. Percola, please introduce yourself and begin your testimony.
Yes. Members of the committee, I want to thank you, first of all, for the opportunity to be here to testify. My name is Josh Percola. I'm a police officer with the Coon Rapids Police Department. and currently assigned to the Investigations Division. My background consists of investigating complex retail crimes along with organized retail crime. I'm also as Bruce stated, I'm the Vice President of the Minnesota Organized Retail Crime Association, and I would like to share with you my experiences involving a gift card investigation. I will also be sharing the experiences on behalf of Detective Newman from the Coon Rapids Police Department, who is also here with me and played a pivotal role in this investigation. In April of 2024, the Coon Rapids Police Department was contacted by a retail business who noticed increased suspicious activity regarding gift cards. The suspects were taking and placing unpurchased gift cards from the shelves at tremendous frequency. The suspects would visit multiple retailers across the metro area, sometimes making 15+ stops at multiple retail locations across the metro area. And during their stops, they would be swapping gift cards, making 15 stops on any given day. The reported loss for one retailer involved was over $350,000 across multiple locations during the initial report of this incident. Detective Newman and I agreed to investigate the gift card activity, and little did we know at the time that this investigation would last approximately 7 months and lead us to discover a transnational criminal organization operating right here in Minnesota. The structure for this transnational criminal organization involves suspects who would take handfuls of unpurchased gift cards and leave the store. The suspects would return to a home typically provided to them and remove the security features on the gift card and record the gift card number and security PIN number. After dismantling the gift card, the suspects would creatively replace the scratched off security strip, reassemble the gift card packaging to make it look unaltered, return to the store, and place the compromised gift cards back on the shelf. The gift card numbers would then be shared amongst the organization members and their bosses. Those numbers, gift card numbers, were sold to unknown individuals in other states who would wait until the compromised gift cards were purchased. When a gift card was loaded with the funds, the money would be immediately drained and used to primarily purchase electronics to be sold by this criminal organization. The Coon Rapids Police Department tirelessly spent months attempting to learn and understand the operations of this criminal organization. With the use of physical surveillance, electronic surveillance, coordination with retailers, we established 2 involved residences where we believe the criminal organization was using it as their base of operations. As the investigation continued, we identified 13 individuals who were actively participating in the taking and placing of gift cards. We also observed several of these other suspects conduct this scheme in other states, but ultimately they always returned back to Minnesota. 7 months into the investigation, we gathered enough information to conduct 2 search warrants at 2 separate locations. Due to the complex nature of this case and individuals involved, we needed to conduct these residential search warrants simultaneously. With the assistance of the Ramsey County Sheriff's Office, Homeland Security Investigations, the Internal Revenue Service, the United States Postal Inspection Service, and the Minnesota Bureau of Criminal Apprehension, over 80 federal, state, and local law enforcement officers participated in executing these residential search warrants. The first residents revealed their base of operation for the gift card altering. We located several workstations fixed with hot glue guns, heat guns, and heat pads used to reattach these security strips. We located and recovered over 16,000 gift cards that were in the process of being altered before they could be placed back on the store shelves. To our surprise, we also found that these organizations were not limiting themselves to one crime at a time to defraud innocent Minnesotans. We located over 135 pieces of banking information that were linked to opening fraudulent bank accounts with fake passports across the country. This information was used and shared with other law enforcement agencies in California and Nevada who also had suspects tied to our criminal organization. The second residence yielded evidence of possible human and labor trafficking related to this transnational criminal organization. This information showed how complex and intricate these criminal organizations operate and also how they diversify. Current criminal statute only allows us to pursue the misdemeanor theft. As Bruce stated earlier, current Minnesota law only allows us to explore criminal charges tied to the value of the plastic itself, because the cards have not been loaded yet with value. The harm does not stop at the retailer, but it's also passed on to the consumer as well. I wanted to share 2 quick conversations I had with some victims, some individuals who were impacted by the gift card fraud. The first victim I had spoken to who reported no funds on their gift cards after a purchase. One of the victims described the embarrassment of giving a gift card to her child's elementary school teacher to purchase classroom supplies. When the teacher went to purchase the supplies with the gift card, the funds were wiped and the gift card no longer had a balance. The victim had to have an awkward conversation with the teacher about the 0 balance on the gift card. The second one that really struck with me was another victim had given a gift card to a struggling mother with a newborn child. The mother went to purchase diapers and formula for her newborn child. Once at the register, the mother was told the balance on her $200 gift card was 0 and had to leave the store without being able to purchase diapers and formula. And many of you probably have children here, but as a father of 3, that absolutely broke my heart. I don't know what I would do if my wife went to the store and no money was on that gift card, especially to those who are in need. With the introduction of this bill and your help, it gives law enforcement and retailers a significant advantage to combat and prevent gift card fraud. While this specific bill aims towards gift card fraud, it gives law enforcement the ability to stop these diversified criminal enterprises from committing additional fraud schemes against innocent Minnesotans. Thank you.
Thank you. Any questions or comments from members of the committee? All right, seeing none, Senator Duckworth, any final thoughts?
Yes, Madam Chair, just briefly. I noticed a few more folks are here, and I just want to reiterate what I said at the very beginning. I'm very honored to have a co-author of such high esteem on this bill with me. And I also want to thank Coon Rapids Police Department for all the effort and work they put into that particular investigation, which I know is still ongoing. But I think without that example specifically and all the work they've done, that we would still be trying to figure out a way to wrap our minds around this and not have a bill before us. So really appreciate their hard work, and it's led to what will hopefully be a really good solution to this problem.
Thank you, Senator Duckworth.
Madam Chair.
Senator Westrom.
Madam Chair, I spurred a little bit of a question, but quickly to the Coon Rapids Police. You mentioned you found other crimes that they were a part of. Can you elaborate on them just a little bit more? Was it kind of tied to retail and you said bank statements? Just any more depth on that? What else you found with it?
Yes, absolutely, Senator. So when we initially found all of those bank documents, they were tied to a common scheme. It's called check kiting. So this transnational group in particular was involved with chip walking. If you're familiar with that, you go into a casino, obtain a loan, receive X amount of dollars. You leave with those chips. You give those casino chips to a bunch of other people involved in this group, and then they go in and cash them, and that's kind of how they wash their money. The banking documents in particular were tied to a case that was ongoing with Secret Service out in Nevada, where these individuals were opening up these bank accounts, sending the bank account information to the individuals in Nevada. They would deposit money that they received from the chip walking into the account. So let's say you have $7,000 in your account. They would then have somebody else issue them a check, usually a phony employment check, and that would be for $7,000. So they would deposit that check. They would withdraw that $7,000 in chip money that they had placed, and then depending on the banking institution, they allow you to take out a certain percentage of the deposited check. Usually if you have that much money in there, they'll let you take out the full amount of the check. However, once the check would be deposited, they would then, an example, they would withdraw $14,000, and by the time the check reached the bank or cleared the bank, that bank account would then be negative $7,000, and these banking institutions would have no idea who the individual is that opened up this account because they used fraudulent information and fraudulent passports.
Senator Westrom, anything else? All right. Senator Latz.
Madam Chair, I move that Senate File 3330 Madam Chair, I move that Senate File 3338 be recommended to pass and be re-referred to the Senate Committee on Commerce.
On Senator Latz's motion, all those in favor say aye. Aye. Any opposed say no. Motion prevails, and the bill is on its way.
Thank you.
All right. Our next bill will be Senate File 4337, Senator Hemmingsen-Jaeger.
Absolutely.
Senator Hemmingsen-Jaeger, why don't you go ahead and give us an introduction of the bill, and we'll go to your testifier.
Great, thank you. Good afternoon. Thank you so much for the time and attention to this bill. I'm Amanda Hemmingsen-Jaeger. So Senate File 4337, typo, deals kind of with our children that are in foster care. That is really important to me because, you know, foster kids in Minnesota, we take responsibility for them. So I'm very honored to be carrying this bill. Under our child protection statutes, counties are required to help kids who are aging out of foster care obtain the documents that they need to transition into adulthood and independence. Documents can include birth certificates and permanent residence cards, for example. The unfortunate reality is that these agencies do not have the adequate resources to enable them to help these children in this situation to get the documents that they need. But at the same time, there are some legal service providers who have skills and expertise to assist the counties to help these kids. This bill comes in to appropriate $300,000 to the Department of Public Safety for a competitive grant program to help ease this burden on our counties, which we've been hearing a lot about. It targets a sum to the kids most in need, kids who have or are eligible for legal status, and these are kids who have often been abused, neglected, and abandoned, and wound up in the system. We estimate that the funding could help about 200 kids. To be eligible to apply, the Legal Services Organization must demonstrate an existing partnership with the County Social Services Agency, meaning a successful working relationship is already there. The path for these kids is often really complex, it's time-consuming, and it's difficult for kids to navigate this alone. So in addition, recent changes in law have included labor trafficking is now a form of child maltreatment in Minnesota, and the bill, the children in this bill is aimed at are particularly high risk for labor trafficking as well. So I feel it's fairly straightforward. Again, I appreciate your attention, and I would love to hand it over to a testifier.
All right, thank you, Senator. We have slated for testimony Madeline Lohman from the Advocates for Human Rights.
Thank you for having me.
Introduce yourself.
Thank you, Mr. Chair and members. Thank you, Senator Hemmingsen-Jaeger, for introducing this bill and having me testify today. I'm Madeline Lohman. I'm the Advocacy and Outreach Director with the Advocates for Human Rights. The Advocates is a Minnesota-based nonprofit that provides immigration legal services to people fleeing persecution, victims of sex and labor trafficking, and unaccompanied children. Based on that work, I can speak to the impact of this bill on unaccompanied children, though the actual scope of the bill will positively impact other immigrant children as well. In our legal services, we work with unaccompanied children who often face instability when they arrive in Minnesota. Some are placed with relatives or family friends who may struggle to meet their needs. Others arrive without any family support in the state and enter foster care. In these situations, County Child Protective Services may be involved. Sometimes counties identify a child and then discover they need immigration assistance. Sometimes, during our legal screening, we identify a child who needs county support. Right now, as the Senator described, both sides of the relationship face barriers to effective collaboration. The competitive grant program established by this bill would significantly reduce those barriers and allow counties and legal service providers to work together more effectively. The need for this bill is not abstract. Since 2020, over 4,000 unaccompanied children have been released to sponsors in Minnesota. Many of these children are thriving, but for those who are not, this bill is a lifeline. The Advocates currently has open cases for 7 children who would be directly impacted by improved coordination between county child protection and immigration legal service providers. These children live all over the state. One is in Northwest Minnesota, another in Southwest, 3 in Southeast Minnesota, and only 2 in the 7-county metro area, making the scarcity of immigration legal services outside the metro area especially critical. The children range in age from under 10 years old to 17. 2 are in foster care, having fled abusive families in their home countries. 2 were living in Minnesota and experienced severe abuse by a step-parent, so CPS removed them from their homes. Another came to Minnesota with a parent, but was later removed from their care because of neglect. At least 3 experienced labor trafficking at the hands of their abusers. In addition to physical safety, these children need stability, trusted adults, and help navigating processes that are far too complex to manage alone, which is all part of what we do as legal service providers. These children who have endured horrific experiences deserve our care and protection. Part of that care includes ensuring they have the identity documents they need so that as they grow, they can secure employment and successfully transition to adulthood. This bill will foster the cross-system partnerships necessary to make that possible. I respectfully request your support for it. Thank you.
All right, any questions for Ms. Lohman? Otherwise, we have a few others who are here also to answer questions from legal aid. No questions for Ms. Lohman? All right, thank you for your testimony. Any discussion or questions for the author of the bill or on the topic? Members, Senator Holmstrom.
Thank you, Chair Latz. Senator Hemmingsen-Jaeger? Perfect. I just noticed that normally when I see applications for appropriations, we have some sort of reporting mechanism. I noticed that there's not a reporting mechanism in here. Do we have any concern about fraud that might occur, or are you open to adding such a provision?
Senator Hemmingsen-Jaeger.
Yeah, I appreciate the question. I think how we have it laid out, where we talk about having an existing partnership, working with the counties, I do think that there are some mechanisms in there, but if you have something in mind, I'm always open to having a conversation.
Senator Holmstrom.
Senator Latz, what's the path of this bill?
Next stop is Health and Human Services.
Okay.
Senator Holmstrom.
So, Senator, yeah, I will follow up on that. I think that there might be something worth adding, just common language for adding an annual report or something of that nature. If you're open to working on that, I would certainly be open to doing so.
Sure, we can take a look.
Senator Limmer.
Thank you, Mr. Chair. Senator, I see on line 2.7, there's a reference to good standing. 2.7. And I don't know if that's a word of art or if there's a definition to what good standing is. Could you tell me what that would mean?
Senator,
seems like a subjective standard.
Senator Hemmingsen-Jaeger.
Yeah, if I could either have our counsel or maybe one of my testifiers kind of elaborate on that, please.
Ms. Primo.
Mr. Chair and members, I think under the corporate statutes and possibly under statutes governing 501c3 corporations, it is a term of art, but I'd have to look it up and update the committee shortly.
All right. Senator Limmer, did you have any other question while we're waiting for that?
Not at this time, Mr. Chair.
All right. Any other questions or discussion from members of the committee? I can't tell if the people standing in the back consulting are trying to figure out an answer to this question or not. If you know it, come on forward. Mr. Elwood.
Thank you, Mr. Chair and Senator Limmer. I think the answer is that under the county, the processes of the counties, that good standing seems to be a common term, common usage for organizations that are provided with any kind of funding. So I think it's just a term of common usage.
Mr. Chair.
Senator Limmer.
Mr. Chair, in this case, the term in good standing is a qualifier. And the way it's presented in the bill, and that's on line 2.7. And as a qualifier, I would think it should have some kind of definition.
We have an answer from council. Ms. Primo.
Mr. Chair and members, I interpret good standing to reference that the corporation is in compliance with various regulations that govern it. So these entities would be required to file with the Secretary of State. And so I think those statutes would govern whether they're in good standing. And there is a definition of good standing under 5.26, section 5.26. And it provides that good standing means that a business entity or other filer of an assumed name or trademark filing has complied with various registrations and the appropriate paperwork to maintain good standing. And it appears, the term appears in various nonprofit statutes as well as Secretary of State filing statutes. So I think that's what it's intended to get at.
Senator Limmer. All right.
No, thank you.
Any further discussion? Senator Kroon and then Senator Westrom.
Thank you, Mr. Chair. So kind of touching on what Senator Holmstrom talked about, I'm just trying to understand the intent of the bill. And so we have applicants for this that are going to be nonprofit organizations. Is there any way the public can ultimately determine which nonprofit organizations got the money under this program?
Senator Hemmingsen-Jaeger.
Trying to see if I understand your question. So you're just asking if the public would know who received the grant?
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. Yeah, in the absence of reporting requirements is kind of where I start my questioning. Is there any way that the public's going to be able to monitor this program and understand where the money went, like which nonprofits got the money?
Do you want to answer?
Mr. Elwood.
Mr. Chair, Senator Kroon, the money would be coming through the Department of Public Safety, and typically, it's my understanding that when grants are let, they're on the websites, and it's a common practice of agencies to identify on these grant programs who receives the grants. We have been in contact with the DPS. I don't know if anybody's here today, but we've been communicating with them, and I can certainly make sure that this is public record.
Senator Kroon.
Thank you, Mr. Chair. And if that's how it normally would be, and we don't need to do anything in this bill to make sure that's the case, then that would be good. That's, I guess, the heart of what my question was, is do we need to do anything in this specific bill to make sure that that happens? Or is that covered in a different section of law that would automatically loop this bill into it and make sure that happens? And I don't know the answer to that question, but that and then the reporting requirements beyond that, I think maybe what normally could be done is there could be reports to the legislature, not just about who gets the money, but what it's doing, what impacts, what effects it might have. Perhaps that's maybe what Senator Holmstrom was getting at. But I'm going to move on to the confidentiality provision in subdivision 5. I understand that it's classified as private data on individuals, which is a classification in our Data Practices Act. but can you tell me what the additional language starting in line 2.25 with notwithstanding to the end of the page, what additional confidentiality does that provide here beyond just having the classification of private data?
Senator Hemmingsen-Jaeger.
Yeah, repeat that one more time so I can write it down more clearly.
Mr. Chair.
Senator Kroon.
Thank you, Mr. Chair. My question relates to subdivision 5. The 2.22 to 2.24 basically defines the data or classifies the data as private data on individuals under our Data Practices Act. My question is, starting on line 225, there's a notwithstanding any law to the contrary, the agency must not share or disseminate data classified under this paragraph except, and that lists 2 exceptions. My question is, what does that additional provision in the confidentiality clause, what additional confidentiality does that provide than if that were not in there and it were just classified as private data on individuals?
Okay.
Senator Hemmingsen-Jaeger.
It's very technical. They're conversing right now, if I may
Well, we give
it up to
the
them.
testifiers a moment to analyze the question
Chair.
and provide us with a response. Senator Kroon. I think you're ready.
Another way to approach it, and obviously I welcome the response to my question, but another way to approach it is to see if this notwithstanding language in the confidentiality clause is present in any other statute, and maybe council could help too. That could be another way to approach it.
Ms. Primo. Unless, do you have a response? Go ahead and identify yourself for the record, please.
Good afternoon, Allison Griffith with Mid-Minnesota Legal Aid. The language was added to ensure that this very private data of foster youth who don't have any adult to advocate for them and must rely on the county is protected from discovery via Data Practices Act. It's very personal data pertaining to youth.
Does that relate specifically to the youth, but is otherwise does not apply to the grant, the granting, or the organization that receives the grant, the amount of the grant, the particulars of the organization?
Precisely correct. The information regarding which agencies would receive the grant would be fully disclosed to the public, and it's a competitive grant program. So the agencies would have to prove their ability to serve youth and meet the terms of the proposed, the criteria for expertise, the relationship with the county, and the information regarding who receives the funds would be fully available to the public.
Senator Kroon.
Thank you, Mr. Chair, but wouldn't that, classifying it as private data, wouldn't that achieve the objective as well that you just described? And why would we need the additional language starting in 2.25?
We could certainly take that back, and
Ms. Griffith.
apologies. It's my first time here.
No problem. Just so that we can, the record needs to be clear and the conversation is a little more coordinated if you do it through the chair. So.
Thank you, sir. Yes, we could certainly take that back and double check on if the language would achieve that.
So this would be the committee where we address that question, I think. Correct, Ms. Primo? So there's no taking it back. If the bill goes on to another committee, the alternative is to lay it on the table, let you work on it until we've got more clarity on it. And we can even just bring it back at the end of the agenda today if you think you can figure that out in that time.
Mr. Chair.
Senator Hemmingsen-Jaeger.
If I could, my data classifications are a little rusty, but I know there's differences between like private data, confidential data. Is it, maybe if I could ask counsel, under the umbrella of private data, my understanding is, especially with kids, we might want to be even more sensitive, and that would be why we would be adding these provisions. So if that question makes sense.
Ms. Primo.
Mr. Chair and members, the language could be slightly clarified, and just my understanding is that some of this data could relate to the work of an attorney. Is that correct? Okay, to the work of the attorney. So one thing could be to just clarify that this data doesn't govern data that's governed by 13.393, which governs the work of an attorney, and none of that is even subject to the Data Practices Act. That's governed by rules that govern the work product and confidentiality owed by an attorney. But then it's the other data that may remain that's maybe not related to the legal representation that you're trying to get at. And so then you'd add some language just to clarify that. And then I think what you would do is at line 2.25, you delete notwithstanding any law to the contrary. And then the rest of that sentence would read, the agency may share or disseminate private data classified under this paragraph to, for those purposes. Because I think the idea is that it's not that you're notwithstanding other laws, it's that you're classifying this data as private, but then you're saying, okay, this private data that we've just classified, it's okay to share for clauses, for the purposes of 1, 2, 3. I think that's how the structure might work, and if I can draft that and write it as a written amendment, because I think it's a little maybe messy to do it as an oral, but happy to do whatever works for the committee.
Senator Kroon, you started us down this path. What do you think of that?
Well, clearly, just from a drafting perspective, to not have two negatives, the way council just explained that makes some sense, that it's taking the already classified private data and saying that it may be shared for these 3 specific purposes is a lot better way of saying it than to say, notwithstanding any law to the contrary, you may not share except for these 3 things. Very confusing drafting. And if that is the intent, then I think that amendment would certainly make the bill better.
Ms. Primo, I guess we'll leave it up to you if you wish to draft it as a separate amendment, or we can do it as an oral amendment. What does Senator Hemmingsen-Jaeger think about this idea?
I would consider it friendly. I appreciate it.
It's up to you, Ms. Primo. You want to take a few minutes to draft it up? I think you'd be more comfortable with that.
Yeah.
Okay.
Yeah. Thank you.
We're going to give Ms. Primo a few minutes to draft it up as a written amendment that can be distributed. And while she's doing that, I do have a question on line 2.22. The government data of the grantee, is that the data on the individual child that is being referenced?
Yes, relates to services provided to a child. Okay.
Senator Hemmingsen-Jaeger.
Related to the services to the child.
I'm just going to let her answer so I don't say the wrong thing, if you wouldn't mind.
No problem. Ms. Griffith.
Thank you. Yes, the data referenced is regarding the services provided to the child by the responsible social services agency.
Okay, so the data about the grantee itself is not made confidential. It's only the data relating to the services provided to a child.
Yes.
So is it the services that you're trying to keep confidential, or the identifying information relating to the child that you're trying to keep confidential?
It's the information regarding the child and details regarding services provided by the attorneys that would serve the youth to ensure that they have access to the documents that we're seeking to ensure youth are able to obtain as the goal of this legislation.
Mr. Chair, if I could have Madeline also offer some insight,
Ms.
please.
Lohman.
I think the concern is that if you specify the services that the grantee has provided to a specific child, you're also perhaps revealing information about incredibly personal things that have happened to that child, such as if they're being assisted with a T visa, then they've experienced some form of trafficking, and that may be something that should not be associated with a child under the care of a particular county. And so I think the nature of the services can be revealing of personal data about that child, even if it seems like it's just a tracking mechanism for the grantee.
It could, as a practical matter, help identify the child.
Yeah.
Which is what you're really trying to protect against?
Yeah, and identify aspects of the child's experience that shouldn't be made public.
I suppose if there's some unidentified child experienced this trauma, but there's only 2 children receiving services by a particular grantee, might not be too hard to figure out who it is, right?
Yeah.
So it sounds like the concern is not really the nature of the services themselves or the nature of the condition that is being treated with the services, but how it might end up revealing the identity of the child that is in that position. Is that a fair characterization?
Yeah, I think that would be how I would characterize it. I think I appreciate that. I think a lot of the senator's concerns are coming from a desire to make sure public funds are stewarded and overseen correctly. And I think, there'll be further conversations about what that reporting might look like. And perhaps there's things that could be part of that report that aren't the specific kinds of legal services provided to the child, but hours spent providing legal services or other metrics that might not reveal anything about the child, but would demonstrate that the grantee was carrying out their obligations.
Ms. Primo apparently has an oral amendment to address this. Senator Kroon, did you want to be heard before she does that?
Thank you, Mr. Chair. I guess just to pick up on this exact point on your last question, and then taking into account the response, I think I understand what they're getting at. My problem is the relates to in 2.23 is too broad. I think that needs to be narrowed up, and I'm thinking about language, but that was my thought on your exact question. Like, yes, we don't want the services that could be identifiable to a specific child to be public, but putting the relates to basically means any data that the grantee has could potentially relate to that. I just think that's too broad of a term.
Well, think quickly. Ms. Primo, let's address the following sentence first with what you were working on to amend line 2.25. Do you have a proposed oral amendment for that while Senator Kroon is considering how to respond to the relates concern?
Mr. Chair and members, I had something that kind of works for that whole subdivision, including the lines that precede line 2.25. So it's a bit of a long one, but I could do just. Yeah.
Well, Ms. Primo, does what you have also address the concern just raised by Senator Kroon about the word relates to?
I am still using the term relates to, but I'm wondering if the way I have it drafted here may tighten it up enough to address Senator Kroon's concerns. I could read it and go from there.
Let's try it, Ms. Primo.
Okay, Mr. Chair and members. Page 2, line 22, delete confidentiality, insert data privacy. Delete the government data of a grantee who is a responsible social. Insert, except as provided under Minnesota statutes, section 13.393, data that relates to services provided to a child under this section, created, collected, received, stored, used, or maintained by a grantee that is a responsible social services agency is private data on individuals as defined in Minnesota statutes, section 13.02 subdivision. Delete, on page 2, delete lines 23 and 24. Page 2, line 25, delete notwithstanding any law to the contrary, comma. Delete must not, insert may. After dissemination, insert private. Line 2.26, delete except, insert 2. And that's the end of the amendment, but I'll just explain it. So the reference to 13.393 is to that statute that governs the work of an attorney, and that would not be subject to the Data Practices Act anyway under that statute. So that would, remain confidential, private, as determined by rules that govern attorneys. And then this gets at the concern about the double negative, hopefully, in the way that Senator Croon had mentioned.
Ms. Primo, the only thing I'd suggest beyond that is, since you deleted except and inserted 2, but then the lines 1, 2, and 3 afterward also have the words 2 or something else leading into it, so maybe you don't need the word 2 inserted on 2.26. Do you see where I'm going with that? Do you agree? Okay. Yeah, as follows.
Mr. Chair.
Ms. Primo.
Yes, thank you. That, Mr. Chair, I would just delete except on line 2.26 and not insert anything in its replacement.
Senator Croon. The oral record does not pick up your head nodding, except for the air moving around your microphone.
Thank you, Mr. Chair. I think that is a good amendment, very high quality amendment for the short amount of time that council had to draft it.
Notwithstanding the short amount of time. Senator Hemmingsen-Jaeger, what do you think? Or any of your testifiers?
I think we're in agreement. Very much appreciate your insight and quick thinking, and appreciate the discussion.
I would say it's high quality no matter how much time was involved.
Absolutely.
Senator Croon.
The only thought I had on the relates to it, you could add the identity of a child into that amendment, and that would get at my second concern. Although the way it's drafted, the oral amendment alleviates my second concern a little bit, but that would be the one idea I came up with relating to the second concern.
Ms. Primo.
Mr. Chair and members, should I read the whole amendment again? Or at least just a sentence that may be, okay.
Yes.
So that sentence would read, except as provided under Minnesota statute section 13.393, data that identifies a child receiving services under this section created, collected, received, stored, used, or maintained by a grantee that is a responsible social services agency is private data on individuals.
Okay, so that leaves unprotected data that could be used to identify but doesn't actually name the child.
Mr. Chair.
Senator Croon.
I think we could go back to the way council had it drafted before my latest suggestion.
This is what we do here. We'll get this right.
Mr. Chair.
Senator Croon.
It's just not, there's still a gap there. I think we'll just have to live with relates to for now. I can't think of a better way to get at it. relates to something that could lead to the identity, but then it starts getting a little wordy. So
I think we've made a pretty clear record that we don't want the disclosure of information that could cause the identification of the child receiving the services in any way, shape, or form.
Mr. Chair.
Senator Kroon.
The only concern I had is that somebody, the grantee or something, could overly designate the data as private that doesn't lead to the identity or isn't in this category just by using an expansive definition of relates to. But having said that, I think the amendment that council drafted is very good, and I would support it.
Does anyone want the amendment read one more time? Or do we all understand what we're doing? All right. Senator Kroon moves adoption of the amendment as expressed by council. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Any further discussion? Senator Westrom.
Thank you, Mr. Chair. Senator, just can you give me a recap of kind of who's the target audience here? It's trying to establish somebody that's not a citizen, but what their legal status is. Is that the primary focus of this, or who would all be covered under your legislation?
Senator Hemmingsen-Jaeger.
My understanding is it's really just foster care kids in general. If there are some kids that are immigrants, then we want to make sure that we are getting them their documents if they're in the middle of legal status to help them be on their way. Because we know that if we can get these kids set up for success, we can keep them out of the criminal justice system. We can help them get a good start to being working, thriving adults.
Senator Westrom.
So, Mr. Chair, Senator, is that your main target in bringing this legislation forward, or what do we currently do if it's not primarily targeted at children of immigrants that don't have legal status here?
Senator Hemmingsen-Jaeger.
To get deeper into that, I'm going to have Ms. Lohman elaborate.
Ms. Lohman.
So one of the challenges is that for child protection workers, differentiating whether someone is a U.S. citizen or has a different permanent status or can secure that permanent status or has no pathway to status is an incredibly complicated question. And so if they encounter a child who appears to be a foreign national and that child does not know their status, which is actually very common, the child protection worker may also not know how to get them their birth certificate, how to get them a social security card, because the determination of whether they're eligible for that really does require interaction with the immigration legal service provider. So this gives them the resource and the support they need to make that determination and to ensure that children have the documentation and the status they're entitled to in order to be able to thrive. So it's not, it's really applying to all of those children who might fall into that pattern. Some of them are going to be, we work with a very narrow category of children who are unaccompanied and have been abused, abandoned, and neglected by their parents, and that's why they're encountering us. But there would be a larger group of children that child protection might encounter that could benefit from these services because the questions around status are so complicated.
Senator Westrom.
So, Mr. Chair, and I guess the disconnect I'm having is what have we done for all these decades before, or is this primarily driven by a higher number of children coming into the system that you don't know the legal status? Is that what's driving it, or how have we done it for decades before without this legislation?
Ms. Lohman.
So prior, there's just been an incredibly difficult experience for county social services trying to procure these resources for their children. That's one of the reasons we've come forward with this, is because in our work with the counties, we hear again and again from county social workers the struggles that they have in meeting these needs. And then as immigration legal service providers, we also face really high caseloads that then make it hard for us to appropriately respond in a timely fashion. And so we always want to prioritize the needs and best interests of the child, and that is something that can be really difficult in the current system. So this is to help reduce those barriers on both sides, the county side and the legal service provider side. Because right now it happens, but it's very difficult, it's very challenging, and especially for county social services that don't have existing connections to a provider.
So,
I don't know if you want.
So,
Ms. Griffith, to the same question, then we'll go back to Senator Westman.
Mr. Chair, this is already a mandate, so the county workers that we encounter are concerned and really want to comply with Minnesota Statute 260C, .452 subdivision 4C, which requires that county workers obtain this documentation for youth in their care, but really need the resources in order to be able to get these youth this documentation so that they can set youth up on the path for success that the Senator is seeking to achieve for them. So we as providers, are able, the provider community is able to assist with this, and the county workers want to get kids these documents, but the resource piece is the missing component. And we would be able to serve 200 youth with this legislation in order to comply with that existing mandate that is currently unfunded.
Senator Western.
Mr. Chair, and to either testifier, so would you say it's fair that the workload has just dramatically increased, and that's what's kind of brought it to the point of needing more resources or this legislation? Is that a fair statement?
I think it
Ms.
is.
Lohman.
Sorry. Excuse me, Senator Latz. I think it's fair to say that the workload has increased, but it has also always been quite challenging. There's also been changes in the law. So labor trafficking is newly a form of child maltreatment, which is an additional mandate for child protection. So there's been changes on both sides in the number of children that need to be served and in the kinds of services and issues that child protection has to cover.
Last question, Mr. Chair. Thank you for your response. So we just had the discussion about the confidentiality or the data privacy and information not getting shared with other partners, whether it's INS or other law enforcement. Is there any part of this legislation that is going to, is it be a workaround that basically restricts cooperation between social services and federal agencies that might be enforcing border security or border laws that the nation has? Is this being driven by any of those, or it seems like it's not? But I just wanted to ask the testifiers, is this going to restrict it or make it harder for the federal government to be able to interact and find out who has the legal status or who doesn't have the legal status?
Ms. Lohman.
Thank you, Chair. This doesn't change any of the current policies around working with federal immigration enforcement. So counties often have their own ordinances or laws around that. This doesn't change any of them. It doesn't change any of the federally or state mandated rules around what information can and cannot be shared. So it should make no difference to the ability of federal law enforcement, immigration enforcement to carry out their duties. It was entirely motivated by our interactions with county social service workers who expressed their strong concerns that they were not able to effectively serve this population of children.
Senator Hemmingsen-Jaeger.
Thank you, Chair. I just do want to stress, too, that I remember in Human Services and Health and Children and Families, back when I was in the House, we talked about like homeless youth, and in previous work too, where sometimes homeless youth can become foster youth, or they're foster youth and they can run away, become homeless youth, and just getting documents to even like get a job or get an ID can sometimes be really challenging. So I think, we need to remember that this is the broader population of foster youth who are under the care of the state of Minnesota. And we just want to make sure that they have the counties have the resources to help these complex kids with these complex issues, again, get the documents that they need to be able to kind of go further in their lives into adulthood.
We'll ask the court reporter to strike the testifier's reference to the other body by name.
Apologies.
Any further discussion from members of the committee? I'm afraid we've created one more senator that regrets having to come through Judiciary Committee today. Senator Holmstrom.
Thank you, Chair. Senator, I see that throughout the bill, there seems to be an interchanging of the word child and youth. Is the bill specifically referencing the minor children? So I've seen youth be used up to 23, 24 years old.
Senator Hemmingsen-Jaeger.
So my understanding is that there are some children that are foster youth that can actually be served above the age of 18. So that's kind of where youth and child come in.
Seeing no further discussion on Senate File 4337, Senator Clark moves that Senate File 4337 as amended be recommended to pass and be re-referred to the Committee on Health and Human Services. All those in favor say aye. Aye. Opposed? Motion prevails. All right, now members, we're going to go to Senate File 3872, Senator Oumou Verbeten. Thank you, Senator Hemmingsen-Jaeger. You're welcome back anytime.
Thank you, Chair.
Senator Oumou Verbeten, when you're ready, go ahead and describe your bill, please.
Thank you, Mr. Chair. I have a few amendments. I think what would be the best way to approach this is to adopt the A1 authors amendment, which just removes a repealer that we don't want to be a part of the bill. Then I can describe the bill and describe some of the work that was done and a compromise made for the A4 amendment, and then take that up.
All right, Senator Oumou Verbeten moves adoption of the A1 amendment as an author's amendment. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Oumou Verbeten.
Thank you, Mr. Chair. Senate File 3872 is DPS OJP policy bill, and it classifies DPS research data on individuals as private data. OJP houses Minnesota Statistical Analysis Center, which is responsible for collecting, analyzing, and distributing crime and justice-related data. This charge requires OJP to collect research data on individuals. However, because this data is not currently classified, it is presumptively public. Ensuring this research data on individuals is private is consistent with ethical standards and required for federally funded research. Summary data would remain public. In addition to making research data on individuals private, this bill would clarify that case support data collected from families and victims through the work of Missing and Murdered Indigenous Relatives Office, as well as the Missing and Murdered Black Women and Girls Office, are also classified as private. Lastly, the bill removes references in statute to outdated terminology related to domestic violence throughout Minnesota statutes. You should also have a letter of support from Violence Free Minnesota, which just talks about survivors facing ongoing fear of retaliation, harassment, and emotional harm, and why it's so important to make sure that any of that identifying information remains confidential to give them safety and security. So that's what the bill does. We had some conversations with Minnesotans for open government about making sure that our intention of protecting the subjects of the research is what the bill does, rather than preventing the public from knowing about the research that OJP is doing. And so that the result of those conversations is the language before us in the A4 amendment, which really just clarifies that a person's name, address, email address, telephone number, date of birth, employer, kind of those actual identifying pieces are to remain private, so that those survivors aren't exposed. And also want to thank Senator Kroon for his support in working with the Minnesotans for Open Government and OJP on this to get that language. So hopefully that gives people an understanding of why the bill is being brought forward, the conversations that have taken place, and then the A4 amendment that we want to add on to the bill just to get the right balance.
Senator Oumou Verbeten moves adoption of the A4 amendment. Is there any discussion? Not seeing any. All in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Senator Oumou Verbeten, you have a testifier sitting next to you. Is that person here just to answer questions if necessary?
Thank you, Mr. Chair. Yes, we have the OJP Director, Kim Babine, here to answer any questions if there are any for members.
Good answer, Senator. Is there any discussion from members of the committee on Senate File 3872 as amended? I am not seeing any. Where's it go?
We're just laying it over.
Senate File 3872 is laid over. Thank you. Members, we're going to bring back Senate File 3338. Senator Pappas, having voted on the prevailing side, moves to reconsider Senate File 3338. I'll tell you what, well, it's not, before she makes that motion, I'm going to tell you why we're going down this path. One is we need to add an effective date. And number two is the Commerce Committee has declined jurisdiction over it, so we're going to send it straight to the floor. With that predicate, Senator Pappas moves to reconsider Senate File 3338. All those in favor say aye. Aye. Opposed? Motion prevails. Senate File 3338 is reconsidered and before the committee again. Mr. Backus, on the effective date.
Mr. Chair, members, and I apologize, I forgot to mention this while it was up earlier. The change would be on page 3, line 7, delete 2025 and insert 2026, period. Not period.
Any questions or discussion from members of the committee? Senator Westland moves adoption of the amendment as described by counsel. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. All right, Senator Oumou Verbeten moves that Senate File 3338 as amended be recommended to pass and be sent to the Senate floor. All those in favor say aye. Aye. Opposed? Motion prevails. Thank you, members. All right, next up, Senator Clark, Senate File 3958.
We're looking for him right now.
Or Senator Clark, speak now or forever hold your peace. Well, the only other senator with a bill before us is Senator Gustafson,
She'll be on her way over.
who's on her way from another committee.
Or we can take a brief recess because the judicial branch reception is upstairs right now.
Oh. You know what, members? The judicial branch reception is going on as we speak. If any committee should be there, it's the members of this committee. I encourage you to do so. We're going to take a recess for 15 minutes. We're going to reconvene. What?
Now he shows it.
Oh.
What happens when you leave and you don't tell anyone? You get...
All right, we're going to send a note to the judicial branch that Senator Clark has interfered with our committee's ability to join them for the reception.
Start with 39.
And we'll take Senate File 3958. Senator Clark, if you have any testifiers, they can join you at the table. I don't see any.
3958, Chair Latz, 3958.
Senator Clark.
Be very brief. My apologies. Too much water. All right, so Senate File 3958 is changing the reporting date on disaster assistance contingency account. So simply to change the date of that we established in statute from January 15th of each year to January 31st. In short, MMB is required to currently submit a report detailing state disaster assistance appropriations and expenditures during the previous calendar year. Submitting such report on calendar year data can be difficult to accomplish by January 15th, which we give them 2 weeks right now, so want to give them 2 more weeks. A January 31st reporting deadline will still provide the information early in the legislative session. Additionally, beginning in the 2024-2025 biennium, the account can be automatically replenished based on the balance of the general fund. Prior to this, the account was replenished on an ad hoc basis depending on the balance and legislative action. So this change to the account may reduce the need for the legislature to make intermittent one-time appropriations that require legislative action. Basically, they're getting the work done, but they're just sprinting to have to do it, and giving them 2 more weeks will ensure that they are, well, they're still able to get the report to us in time, and gives them 2 more weeks without any real downside.
Senator Clark, is there a separate provision of the bill relating to the account replenishment, or does the change in the reporting date take care of that?
I guess I'll turn back to those folks. I do have phone a friend behind me, but this sort of that automatic replenishment reduces the part of the risk of having it be the date of the report be changed from the 15th to the 31st.
Okay, I just don't see any other amendment in the bill, just the date change. So I'm just wondering where if I'm missing something. Go ahead and identify yourself and your affiliation, please.
Nick Lardner, Director of Budget Policy Analysis at MMB. That change that Senator Clark mentioned happened in 2024, Chapter 123. Has changed statute 16A.286. So based on the balance of the general fund at the close compared to what was estimated, it'll replenish the account up to $50 million.
And that it would automatically happen because of the change in the report date?
No, that's already occurring.
So there's nothing in the bill that changes that replenishment?
No, I think the point that Senator Latz, that Senator Clark was making was that the need for the legislature to act to replenish this account has lessened due to that change in 2024. So pushing the date back 2 weeks for the legislature to receive the information on what happened in the previous calendar year and the balance of the accounts has lessened due to that change.
I see. Okay. Any other questions or discussions from members of the committee? Not seeing any. Senator Clark moves that Senate File 3958 be recommended pass and be referred to the Senate floor. All those in favor say aye.
Aye.
Opposed? Motion prevails. Senator Clark, you have another bill before us, 4145.
Thank you, Chair Latz. Senate File 4145, if enacted, would prohibit landlords from naming minor children as tenants on a lease and prohibit them from naming minor children as defendants in an eviction action. The purpose of enacting this bill is to ensure that minor children who generally do not have the capacity to enter into a binding contract are protected from the consequences of adult tenants not fulfilling their lease obligations. So imagine with me for a moment if you're an 18-year-old young adult trying to rent your first apartment. You're putting in rental applications for different properties, paying the application fees, and keep getting denied for poor rental history. You're confused because this is your first apartment. How could you have poor rental history already? Then you come to find out it's because your parents were evicted when you were living with them as a minor and you were named as the defendant in the eviction case, meaning that you have an eviction on your record. As a minor child, you'd have no reason to know about that eviction or understand the implications it would have for you or your future. But now here you are, a young adult who can't afford to buy a home, and you've never rented on your own, and you can't find a landlord willing to rent to you because your parents were evicted, and that eviction is showing up on the rental history. So you're suffering the consequences of your parents not complying with their lease, even though you, the minor child, couldn't have done anything to prevent the eviction at this time. You've just entered adulthood, and you're already at a severe disadvantage finding rental housing. That's the scenario that we're attempting to address. So when a minor child is named on a lease, similar consequences can arise even when tenants aren't evicted. If the parents and adult tenants don't pay all the rent they owe when they move out, common practice is for landlords to send that debt to collections. When that happens and the minor child is named on the lease, the debt can get put into the minor child's name as well as the parents. So in this situation, when the minor child tries to rent for the first time as an adult as well, the rental applications will be denied for poor credit history. So we should not be subjecting minor children to poor credit and rental history before they've even entered adulthood. Tenants who are renting for the first time on their own should be given every opportunity to be successful renters, regardless of the choices made by their parents or adult tenants whom they've lived with as a minor. I understand there are a couple of folks to testify as well.
All right, we'll invite Michael Dahl from Homeline to come forward, please. I'm going to ask testifiers to try to be succinct so that we can fit everything in today. Mr. Dahl.
Good afternoon, Chair Latz and members of the committee. Thank you for the opportunity to testify in support of Senate File 4145, and thank you to Senator Clark for championing this legislation. My name is Michael Dahl, and I serve as Public Policy Director at Homeline. We provide free legal, organizing, educational, and advocacy services to tenants across the state. Since 1992, we have served more than 357,000 renter households, including in record number last year. As Senator Clark noted, young adults should not have their rental or credit history harmed by the actions of their parents, but the consequences go beyond the record itself. There are real financial impacts. A young adult may pay multiple application fees while searching for a new apartment, costs that add up quickly. And when they later find out that an eviction is on their record, they want to likely pursue an expungement to clear their rental history. That upfront cost is at least $300. Most young renters, that expense is significant. It may not be it may be unaffordable, or it may drain on the savings they have to cover rent, utilities, and other bills. I raise this point because I know financial penalty is an issue of discussion, and in cases like these, the young adult has done nothing wrong. They should have a pathway to be made whole. Thank you again for your opportunity to testify in support of 4145, and I'm open to any questions you may have.
Thank you, Mr. Dahl. Any questions right now for Mr. Dahl? Not seeing any. We'll invite Cecil Smith to come forward from the Multi-Housing Association. Mr. Smith.
Mr. Chair, members of the committee, thank you for the opportunity. My name is Cecil Smith. I represent the Minnesota Multi-Housing Association. We have 2,200 members with 300,000 apartment homes who provide housing for over 600,000 Minnesotans. Let me begin by saying that our organization does not oppose the intent of this bill. Housing providers do not seek to file eviction actions against minors, and we agree that children should not be the subject of eviction proceedings. In the rare circumstance when a minor appears in eviction filings, it is almost always because they were listed on the lease as members of the household, not because they are responsible for lease obligations. However, we do have two concerns with the current language of the bill. The first, paragraph A, would prohibit minors from being listed as tenants on a lease. That provision directly conflicts with Minnesota Statute 504B 216, subdivision B. Under that statute, landlords are required to list tenants occupying the unit on a lease, and the statute does not distinguish between adults and minors. Housing providers with shared metered buildings are therefore required under existing law to list all occupants, including children, on the lease document. Second, we're concerned about the penalty structure in paragraph C. The bill would allow treble damages for violations. Treble damages are typically reserved in statute for the most egregious conduct. intentional wrongdoing, or serious violations. In this situation, however, the issue is most often arises from a clerical or a procedural mistake. Imposing treble damages in that context would be disproportionate to the conduct involved. We believe the bill's core goals can be achieved while addressing our concerns. We've provided language to the bill author to that effect. We appreciate the author's work on the issue, and we hope we can reach agreement. Thank you, Mr. Chair and members.
Thank you, Mr. Smith. Yeah, I was wondering why it is that minors would be possibly listed in an eviction action or on a lease where they're not, obviously not in a position to fulfill the obligations of the lease. There's another statute that actually requires all tenants to be listed in the lease?
That's correct. 504B 216 subdivision 7. In apportioning utilities, we have to list the occupants in each unit so that the formula, which is based upon occupancy, can apportion the utilities appropriately. And under statute, children are still tenants. They have tenant rights, federal housing protections, tenant protections. They are not leaseholders, they are occupants.
So it sounds like line 1.8 of the bill is in contradiction to that 504B provision.
That's correct. That's what we're highlighting.
Senator Clark, what are your thoughts on that?
Chair Latz, I may turn to Mr. Dahl as well, but it does seem that if it's in contradiction, I don't believe that removing lines 1.8 through 1.10 would remove the intention of the bill. But I'll ask Mr. Dahl to comment as well.
Mr. Dahl.
Mr. Chair, we are negotiating this bill in the other house, and one consideration has been to remove subdivision A, where it identifies the minor child as a residential tenant. It's not necessary for that definition, we think, and would remove the concern that Mr. Smith brings up. We just learned of this issue a couple minutes ago, so I'm trying to find the answer that works best. But Section A is one area we're talking about in our negotiations in the House.
Okay, well, you're in the Senate right now, so we're going to do our own negotiations or sorting out of the bill. What is your position as to how we should approach this, Mr. Dahl?
Our position is to get rid of Section A. The subdivision, I don't know the right words, but the Clause A that's on line 1.8.
Senator Clark.
Chair Latz, thank you, and thank you to Mr. Smith for bringing this forward. Yes, the intention, or removing in line 1.8 from A, or remove a residential lease shall not list a minor child of a residential tenant as a tenant.
The whole section can actually go, the whole, up to, and 1.8 to 1.10.
Yes, so Chair Latz, I'll offer an oral amendment that removes lines 1.8 through 1.1.
1.10?
1.10, thank you.
Well, so they're two separate provisions, though. So the second sentence in Clause A refers to a minor if they're the only person renting the unit from the landlord.
Okay,
I guess number one, is that lawful?
Actually, thanks for catching that error. The first way that Senator Latz listed it is the way that we would intend it. If the youth is signing a lease because they are the sole person, they have to be responsible for this section.
Can a minor enter into a lease contract legally as a sole
If they're emancipated, Mr. Chair.
Mr. Smith.
If they are emancipated.
And they can become emancipated from the age 16 and above, is my recollection, under certain circumstances. Is that right?
Chair Latz, I think I would turn to
Senator
counsel
Clark.
on that.
Ms. Primo, do you know anything about the emancipation statutes? I think there are some provisions if someone 16 and older moves out of the household and living on their own or something like that, that they can be, that they're considered to be emancipated, but I don't recall exactly.
Well, this is great.
Mr. Chair and members, I haven't looked at the statute in a long time, but my recollection is that some of this is dictated by case law regarding the specifics of emancipation. And yeah, I would need to refresh my memory on that.
Okay, it looks like Senator Cruin is actively searching there. Senator Westland's waving her hand. Senator Westland.
Remember in law school, those gunners? I was never one of them.
She was a gunner.
I was not. I was quickly reading the case before I got called on.
Gotcha. Senator Westland.
So it appears to me that if a minor goes through an actual court-ordered process, that the process of emancipation grants them legal capacity, the legal capacity of an adult, which means they can enter leases or car purchases. Now, I am a little concerned about, just on the fly, doing some things here, because when we go to the definition section for 504B.001, I hope that we're being thoughtful about this, because if we can resolve this by taking out the part that says a residential lease shall not list a minor, I think that's what we were talking about, that first part of 1.1 or 1.8. It seems right now that anybody dwelling has to be identified on the lease. I have questions about, does the identification have to be that kid's name? Can it be minor child, 18, whatever? If we don't have to fuss with that, and we can just say, if there's a minor child listed on the lease, they shall not be listed on the eviction notice, then my question becomes, but what does the eviction notice require? Does the eviction notice require to list everybody who occupies the dwelling? And I don't know anything about these things, but I want to be very careful about, if we pull a thread and do a quick fix, that we're not creating unintended consequences, as we like to say around here.
I've got a suggested amendment here that might address all of it. Let me throw it out there. Ms. Primo, you'll consider this as well. On line 1.8, before the period, insert unless, and then delete period if, and everything after the period. And then on line 1.9, before minor, insert a period after landlord in place of the comma, and delete the rest of that sentence. So it would read, a residential lease shall not list a minor child of a residential tenant as a tenant unless that child is the minor, unless the minor is the only person renting the unit from the landlord, period. So it would ban listing the minor child as a tenant unless that minor is the only person renting. And they can only be listed, presumably, if they are emancipated, so that should cover it.
Mr. Chair.
If that doesn't do it, we'll keep working on it.
They're always a tenant. They have tenancy rights of occupancy.
I withdraw my proposal.
Mr. Chair.
Mr. Dahl.
Mr. Chair, to deal with one of the issues that Senator Westland was bringing up, in your packet, I believe there's an actual eviction
Can you speak
action.
up, please?
Okay.
Or closer to the mic.
Sure. I want to address one of the issues that Senator Westland raised, Mr. Chair. You have an example in your packet, I believe, that lists an eviction action where it identifies the youth as Jane Doe and John Doe. They may be listed on the lease with their actual name so that a landlord knows who's living in their property. But in an eviction action, they are listed as anonymously. And then later down the page, it shows who the defendants are, the lease parties are, and it identifies the two adults in the situation. So that's how an eviction action should be filed, where If the kids have to be named, they're named anonymously. We want to give landlords the right to know who's renting from their apartment.
Yeah, that's what they're originally talking about doing. Ms. Primo is of the opinion that it's simplest just to delete all of paragraph A and just leave paragraph B as the applicable paragraph.
Chair Latz,
Senator Clark.
I agree, and I believe it still maintains the intent of the rest of the bill by removing lines 1.8 through 1.10. Thank you.
Mr. Smith, what is your position on the proposal to delete paragraph A, line 1.8 to 1.10?
Mr. Chair, that was my recommendation and testimony.
Mr. Dahl, what is your position on that?
I agree. Thank you, Mr. Chair.
Senator Clark, Chief Author.
Chair Latz, yes, I agree as well. And
Senator Clark moves to strike paragraph A, lines 1.8 to 1.10. Any further discussion? All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. Ms. Primo has a recommendation on the effective date paragraph. Ms. Primo.
Mr. Chair and members, now that the substantive provisions are really only about actions filed in housing court or eviction actions, I think we need to update the effective date to reflect that because it's not about the leases. Here is a proposed solution to that. Page 1, line 20, after 2, delete leases, insert eviction actions filed. Line 1.21, delete everything before on, and delete everything after the period, and delete lines 1.22 and 1.23. So the sentence would read, this section is effective August 1st, 2026, and applies to eviction actions filed on or after that date.
Senator Clark.
thank you, Chair Latz. Thank you, Ms. Primo. My reading of that, you know this part of law better than me, so yes.
Either testifiers have an opinion on that? No objections?
No objections.
No objections, Mr. Chair.
Members of the committee. Senator Clark moves the amendment as described by council. All those in favor say aye.
Aye.
Opposed? Motion prevails. The amendment is adopted. To the last question raised by Mr. Smith on the question of damages, I'm not sure that we had a response from Senator Clark or Mr. Dahl to that. What is your position on that?
Chair Latz, I think Mr. Smith raises a good point on treble damages being limited to most egregious pieces. And as we've heard the stories in this, it seems that it is not often done as intentionality, and that's where treble damages often arise. And so I am amenable to removing treble.
Mr. Dahl?
Mr. Chair, I find that acceptable.
Mr. Smith?
Mr. Chair, we do not believe that this merits penalties. We think that this can and should be obviously not happen in the first place, but that the clerk of the court should not be accepting filings that list minors, and that the bench can immediately dismiss cases against minors when it appears on filing and remove them from the case. There's many opportunities for this to be corrected through the process. Furthermore, Minnesota statute already offers tenant protections that only an eviction judgment can be used against a negative rental history for a Minnesota resident applying for rental housing in Minnesota. So just the filing alone is not grounds for a negative rental reference. And so it has to go through many checks, many opportunities to correct this, and only in the circumstances of a judgment would it even appear. And so we think if there are going to be damages, it should be much less than $1,000 because if there is even an affordability issue of filing for a correction, that's a $70 filing fee, and the judge can waive that against the filer.
Do you have a recommended change to this?
I don't have a recommended change, Your Honor. Mr. Chair. We've requested that this provision be removed.
Senator Westland.
Thank you, Mr. Chair. On the eviction notice, does it, in the note, and I can't tell from the one on here, does it list the birth dates of the people who are listed in the eviction notice?
When you file, Mr. Chair, Senator Westland, when you file, you have to list names and date of birth.
Senator Westland. Does anyone know what the court process would be here? I mean, if an action is filed that contradicts the statute here, Mr. Smith has suggested that the clerk of court should reject the filing, or that there be some other immediate dismissal of the filing that contradicts the statute. I'm not quite sure how that process works. Does anyone know? Senator Kroon? You're a real estate attorney.
I was gonna tell a joke, but I so we could go up to the judicial center right now and ask their opinion.
Well, on the other hand, they scheduled their reception during the Judiciary Committee meeting, so.
Chair Latz, I believe the picture's at 2:45.
What's that?
I believe Chair Latz, I believe the picture is at 2:45, so that might be
well.
there.
And the reception lasts till 3:30, so we still have some time. Depends how long Senator Gustafson keeps us here.
Chair Latz,
Senator Clark.
Chair Latz, I think Senator Westland may have a idea.
Oh, Senator Westland, once
Thank
again,
you, Mr.
waving
Chair.
at the back of my head. Go
What's
ahead.
that?
Once again, waving at the back of my head.
That's
Go
okay,
ahead.
sorry. I guess, you know, the concern I have about putting this, the onus of this on the clerks as opposed to the person filing is that's asking our judicial clerks who are, especially in evictions, I imagine, have a pretty significant caseload. I think the onus should be on the landlord not to be including people on an eviction notice that don't belong there. And, you know, they're the ones who are preparing the paperwork, either themselves or with the assistance of an attorney. And I think we rightly put the onus on them not to include minors. And I think expecting our clerks to catch everything, and I don't know if this would be easy or hard for them, but it seems to me to be shifting the burden where it doesn't belong. And so if a landlord knowingly includes a minor on an eviction, I think there should be some potential fine, something for that, but I don't agree that it should be nothing.
Mr.
Chair Latz.
Mr. Chair.
Mr. Dahl.
The filing fee, first of all, can be up to $300, and many of the people that Homeline serves are not income eligible to have their the lesser amount. And so I would ask that we consider the full amount that it could, the fee, or the fee could be to get the record expunged. Also, the lease parties are often listed on the form that I gave. It has a B and a C for two people that are the adults in the household. There's also a section on many leases that list occupants, and occupants would include people that aren't supposed to be named as as defendants in a case like this.
So are you suggesting that it's there really is no reason for there to be an error by a landlord in filing an eviction notice because of these other provisions you've just referred to?
That is what I'm saying, sir. Yes, thank you, sir. Thank you, Chair.
Senator Clark, what do you think we should do about all this?
Thank you, Chair Latz. I'm still of the opinion that we remove trouble, and I think we leave the damages as currently written. As Mr. Smith and others have pointed out, this doesn't happen with regularity, but and so in those limited instances, this is providing a clear way, a clear consequence to that action that the landlord has done incorrectly.
Senator Seeberger.
Thank you, Chair Latz. I'm in agreement that we should remove the word treble. I would also suggest that in line 1.19, we remove all the rest of the language that precedes the phrase for a violation of this section. As members of this committee knows, I am not a big fan of assigning recovery of attorney's fees against one party or another. So while I do believe that a tenant should probably have a right of action against a landlord should this happen, their damages should be limited to actual and consequential damages. So I would move an amendment to delete the word treble from line 1.18 and delete the first part of line 1.19 that precedes the phrase for a violation of this section.
Senator Clark.
Thank you, Chair Latz. And Chair Seeberger, to understand correctly, so on line 1.18, you strike treble. And then on lines 1.19, you strike whichever is greater and reasonable attorney's fees. Is that correct?
Senator Seeberger.
No. In 1.19, we strike the following, or $1,000, whichever is greater, and reasonable attorney's fees.
Thank you, Chair Latz. I would suggest that I would prefer that we keep a dollar amount, and I think $1,000 is an appropriate amount in this instance. So I would respectfully, I like the removal of treble and the whichever is greater piece, but leaving $1,000 to provide a bit more teeth.
So $1,000 would become a floor, basically. So damages would be at least $1,000 the way it's written, unless the actual or consequential damages are greater, and then that becomes the damages amount. I mean, I'll be candid, I'm a little bit concerned about an inadvertent error from a clerk of a property owner that improperly lists in the eviction notice a person that shouldn't be listed there, and that would automatically cost at least $1,000 as damages. Senator Westrom.
Mr. Chair, I would share your concerns. At a minimum, I think we should have language that would say knowingly, but I guess a question for Senator Clark. What do you do in a situation where a child, maybe there was a minor 16 or 17 when they moved in and they've turned 18? It's quite an onus to put on the owner to keep track of all the birthdays. There's logical reasons that an owner would probably want listed all the occupants of a unit, because sometimes city ordinances or other things come into play, so they know there's going to be a total of 6 people, 2 adults and 4 children, minor, when they move in. But there's just a lot of scenarios that are can run through my mind right now that really could be unintended consequences here, and one of those would be inadvertent filings that the attorneys filing these or the owners, don't always keep track of all the kids and birth dates, and sometimes it's very hard to find that information. So you don't know if somebody's 17 months and years old and 11 months, or 18 and years old and 1 month, or the language. So anyways, I just think there's a lot of scenarios. So I share the chair's concerns and would support this amendment, and I would support the initial amendments as Senator Seeberger you offered, would be my thoughts.
So, Senator Clark, I would be absolutely comfortable with actual and consequential damages, whatever they turn out to be. It might be $300, $400 if someone ends up homeless for a month because they can't get into an apartment until they get the record cleared up, and they got to rent a hotel for a month, and that's a cost. That seems to be illogical to put that financial burden on the landlord that made the error that caused it. But if it turns out it's a very small actual damages amount, I'd be a little bit concerned about assigning $1,000 to it, but that's just my reaction here. Mr. Dahl?
Mr. Chair, whatever the amount, there are many places in 504B where it does assign minimums to particular offenses.
Does it?
Yes, there's, and so I leave it to this committee to, there are minimums stated, and if the $1,000 is too much and this is more in line with what other statutes mentioned, it's been $250 or $500. I do think the minor deserves to be made whole, and there are cases where they file for an expungement and it's a $300 fee. And so if that be the basis of the penalty charge, that could be a solution.
Mr. Dahl, I'm not as familiar with the penalty amounts in the other portions of 504B. What are the other numbers that are used there?
Mr. Chair, I don't have the answer to that right now.
Does anyone know? Well, we have an amendment before us from Senator Seeberger.
Chair Latz.
Senator Clark.
As much as I'm not especially keen on removing the $1,000 piece, I'm looking for a better amount, I guess, is what I'm looking for.
Mr. Chair.
Senator Westland.
Sorry.
Mr. Chair, I'm wondering, I think it would be a motion, but there are amendments being proposed on two different lines. I would suggest that we split them and take them separately. I will hold the thought.
Council is conducting some legal research. Mr. Dahl.
Mr. Chair, for the privacy violation, there's a fee of a fine of $500. If that, I'm just providing, I'm trying to talk with some of the attorneys at Homeline to get through this, and they listed that $500 is one example of a penalty, and it's for $500. $500 for a number of offenses, 200 for lease breaking, security deposit withhold is amount the 2 times the security deposit that's being withheld. So there are plenty of examples inside 504B that list particular amounts and varying amounts.
Senator Clark, Senator Seeberger, Senator Westland, thoughts on including a number, no number, pick a different number everyone's maybe happy with? I don't know.
Go ahead.
Mr. Chair,
Senator Seeberger.
I like my motion the way it is.
Senator Westland.
Thank you, Mr. Chair. I was merely suggesting dividing it because I like part of your motion, and the other one I guess what I was thinking is the $1,000 could be 500 and then delete reasonable attorney's fees. So because I think what we've heard is if somebody has the filing fee for something is $300. So it would be removing treble, actual and consequential damages, or $500, whichever is greater, and then eliminate the attorney's fees is just a suggestion. And I understand that you may not agree with that, but I would like to vote for part of your motion, but I don't know if I can vote for the other part.
Senator Clark, your thoughts?
Thank you, Chair Latz. I like the idea of separating dividing the motion on trouble, and then I would be amenable to the solution that Senator Westland had, essentially moving from $1,000 to $500.
All right, Senator Westland has moved to divide the motion into 2 parts. The first part being the content of line 1.18, second part being the content of line 1.19. Is that a correct explanation, Senator Westland? Senator Seeberger, as the maker of the motion, you get to decide which portion of the divided motion will be considered first. What do you prefer?
Well, I'm going to vote no on Senator Westland's motion, but to the extent that it passes, we can consider the second part first.
I think, I can be corrected, but I think it's not really a vote on whether to divide the motion, is it? I think it's just divided on the request, if I remember procedurally. So then it's a question, which one did you want to have considered first, Senator Seeberger?
The second part, 1.19.
Okay, so the motion before the body at this time is to delete line 1.19, delete everything up and including the comma, the second comma. Is that correct, Senator Seeberger?
Technically the 4th comma, but yes.
1, 2, okay, yes, the 4th comma, the comma after the word fees. Okay. Any further discussion on that? Senator Oumou Verbeten.
Thank you, Mr. Chair. Could we just get clarity on what Senator Clark's position is on the amendment?
Senator Clark, to the proposed amendment before the committee at this time. What is your position?
Thank you, Chair Latz. On the amendment regarding line 1.19, I will be voting no.
Any further discussion? All right, all those in favor of the motion to amend as described, the language on 1.19, all those in favor say aye. Aye. Opposed?
No.
The chair is unclear. I'm going to ask for a division. We can do hands. All those in favor, raise your hands. There are 5 in favor. All those opposed? It is 5 to 5. The motion does not prevail. We will now consider the second part of the Senator Seeberger motion, which was on line 1.18, delete the word treble. Any further discussion on that? Senator Clark, your position?
Chair Latz, I will be voting aye on this.
Any other discussion? All those in favor say aye.
Aye.
Opposed? Motion prevails. That portion of the amendment is adopted. Are there any further amendments proposed on this bill? Senator Westland, Senator Oumou Verbeten. You fight it out.
Mr. Chair, I was
Senator
just going to
Oumou Verbeten.
ask Senator Westland, I think you were referencing the filing fee. Was there a reason why we're thinking 500 versus 300 versus like 250 that shows up in other statutes? If we know the exact number of the filing fee, maybe that would be an appropriate minimum amount.
Mr. Chair.
Senator Westland.
So I would like to make an oral amendment on line 1.19, change $1,000 to $300, keep in whichever is greater, and then delete and reasonable attorney's fees and the comma.
Senator Westland moves on line 1.19 to delete 1,000, insert in its place 300, and delete the words "and reasonable attorney's fees," comma. Senator Clark.
Chair Latz, I consider this a friendly amendment.
Any further discussion? All those in favor say aye.
Aye.
Opposed? Motion prevails. That amendment is adopted. Is there any further amendment required by council or offered by any members of the committee? Not seeing it. Senator
Mr. Chair.
Westrom?
Mr. Chair, a question for council, just tracking. Would there have to be any knowledge or knowing intent in here? And if not, what would you suggest for change that would at least establish that it has to be a knowingly violation as opposed to inadvertent?
Ms. Primo.
Mr. Chair and members, the way I read the language, as long as the violation occurred under paragraph B, the listing of a minor child on the complaint, that it would trigger the remedies on the liability. So to get at the issue, you could insert knowing before violation on line 1.19.
Mr. Chair,
Senator
Senator Clark, would you be open to that, or what's your thoughts of knowingly violating the law, the law versus an inadvertent mistake?
Senator Clark.
Thank you, Chair Latz. Thank you, Senator Westrom. I think in this, I'm centering the minor child, and the inadvertent piece would still cause a harm to the minor child. I think we've reduced the damages they can then receive. So maybe it's now more commensurate to what you're describing, whether it's knowing or unknowing. So I would suggest that we not include that phrasing.
So Senator Clark.
Senator Westrom.
How do you square then somebody as that was a minor when the lease began? 1 year goes by, 10 years goes by, and it's just an inadvertent. I mean, how do you find that information out? And how would you propose that as the author of the bill, if that's the case? Because every day something's changing on a birth date, and that just seems to be a pretty wide net that's being cast here.
Senator Clark.
Chair Latz, Senator Westrom. Right now, an eviction notices if the age is not known or under the age of 18, the best practice, I understand, is to list them as John or Jane Doe. And so that would cover the individuals in likely most situations, if not all.
Any further discussion? Senate File 4145.
So Mr. Chair,
Senator Westrom.
I would just offer the oral amendment of knowingly, where council suggested to put it in front of I think the word violation, you said?
Senator Westrom moves to insert the word knowingly on line 1.19 before the word knowing, before line 1, the word violation on line 1.19. Members, I'm concerned about that. It'd be very difficult, if not impossible, to prove intent on something like this, and when the damages are already proposed to be minimum $300 or any actual and consequential damages, going through the process of trying to prove knowing would be really, I think, an insurmountable barrier to any recovery. So I guess I would, personally, I'd oppose the motion. Any further discussion? Senator Clark to that?
Chair Latz, I agree with your assessment of that.
Senator Westrom moves the amendment as described. All those in favor say aye.
Aye.
Opposed?
No.
Motion does not prevail. Any further discussion on Senate File 4145 as amended? Senator Clark moves that Senate File 4145 as amended be recommended to pass and be re-referred to the Senate Committee on Housing and Homelessness. All those, and that it automatically includes the renumbering of the sections as appropriate, right? All those in favor say aye.
Aye.
Opposed? No. Motion prevails. All right, we're done with Senate File 4145. Thank you, members. We are now to Senator Gustafson, Senate File 3907.
Thank you.
So this one's a little wacky. Can I sneak that sign-in sheet from you? Oh, yeah, of course. Do you have a pen? Thank you.
So to just make sure you thank the Bar Association. Yes, yes. Okay.
So quick update for you. So you've got your A2.
Yes.
And then you've got an A8 to the A2. So I
Yep.
added extra copies here.
Okay.
So what I want you to do is do your remarks and then move your A2. And then so you have the A8 to the A2 and you have like all as one author's amendments.
Okay. Sure. I'm grabbing my coffee. I'll go for it. Oh, yeah. Go ahead.
Senator Gustafson.
Thank you,
Senate
Mr.
File
Chair.
3907. Tell us about your bill.
All right, thank you, Mr. Chair. Thank you, committee, for hearing the bill. This bill fills a gap in existing law and protects victims of domestic violence, sexual assault, and other forms of domestic abuse. Domestic violence advocates have seen too many situations where the survivor and the abuser are co-purchasers of a contract for deed, and the abuser abandons the property and stops making contributing payments to the contract. This leaves the survivor, who is able to continue making payments on the contract and wants to remain as the equitable owner of the home, in the predicament of sharing an interest in property forever with a person who has committed domestic violence and is not bearing any responsibility for contract payments, homeowner insurance, property taxes, or maintenance on the home. Currently, there is no viable legal remedy that can extricate the survivor from the untenable and unfair situation. So the process of partition is the closest possibility, but partition contemplates the sale of the property and the division of the proceeds, not the outcome the survivor wants. This bill is brought to me by Standpoint and Legal Aid and is supported by Violence Free Minnesota and MNCASA. And I want to thank Real Property section of the Minnesota State Bar Association for their thorough review and very helpful technical recommendations, which are reflected in the amendments that you'll see before you. And in short, under the bill, a survivor is granted the right to petition the court to extinguish the abuser's interest in the contract for deed if the survivor proves, one, that they have been subject subjected to domestic abuse, sexual assault, sexual extortion, stalking, or harassment. 2, the abuser has not resided in the property for 6 months. And 3, the survivor has made 100% of the payments on the contract for the past 6 months. And of course, because this involves terminating a property right, we have ensured that there is due process, which involves the service of a summons pursuant to the Minnesota Rules of Civil Procedure on the abuser, the contract for deed seller, tax lien holders, and judgment lien holders. And this provides notice and the opportunity to be heard. And I also want to thank Minnesota Indian Affairs Council, who provided their insights and technical assistance. Their input is reflected in the portion of the bill that describes jurisdiction. This section provides that the district court has jurisdiction to hear these cases, but that nothing infringes upon the jurisdiction of a tribal court where one of the parties is an indigenous person or where the property is located within the boundaries of tribal land. So we truly appreciate their help on this bill. I have Bailey Hovland from Standpoint and Brandon Alkery from Minnesota Indian Affairs Council that can speak to the bill later, but Chair, I think we have a couple of amendments to move.
Yeah, thank you, Senator Gustafson. Members, you have in your packet an A2 amendment, which is intended to be an author's amendment, and been handed out an A8 amendment, which amends the A2 amendment, which Senator Gustafson would like incorporated into the A2 amendment. Senator Seeberger, would you move adoption of the amendments as I described? Yes. To the adoption of the A2 amendment as amended by the A8 amendment as author's amendments. All those in favor say aye. 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 Opposed? The motion prevails. The amendments are adopted. Senator Gustafson, did you want to hear from a testifier before we get into further discussion? I understand other amendments are in the packets, but they're anticipated to be discussed by a member of the committee.
Yes, thank you, Chair. We'll have our first testifier go.
Okay, I'm going to ask all testifiers to please be succinct as we are past our expiration date for today's committee hearing, and we'd like to focus on the merits as much as we can rather than on the if there are questions about policy and purpose, we can get into those. Go ahead. Please identify yourself.
Thank you, Mr. Chair. My name is Brandon Elkire. I'm the Executive Director for the Minnesota Indian Affairs Council. I'm just wanting to give a brief support for this bill. Domestic violence is obviously prevalent within Indian country at high rates. We are happy to see something that that helps the victim get untethered from their abusers. So we are highly supportive of this bill. Thank you.
Thank you very much.
Chair, committee, thank you for having us here today. As Senator Gustafson introduced me, my name is Bailey Hovland. I'm a staff attorney at Standpoint. You may be familiar with our work, so I won't wrap it up, but we serve all victim survivors throughout the state of Minnesota. We provide free legal advice, resources, support, et cetera, et cetera. This bill was dreamed up with legal aid in response to calls that I personally received on the action line. Standpoint has a housing program, and I am the sole attorney on that program. I am our housing attorney. And last spring, I received numerous calls indicating that people were having difficulty on a joint contract for deeds with abusive partners. And most of the time, those calls included abandonment and non-payment as forms of continued abuse and control. Financial control is prevalent in domestic abuse and sexual violence cases, especially domestic abuse cases, given the link between domestic abuse and people's housing situations. And it is something that we have attempted to address through the legislature in many different ways, through our coerced debt bill, through our bill allowing a victim of violence to end their lease. This bill is intended to do something similar. It's providing a very narrowly tailored remedy to survivors of domestic violence if they can show the court, number one, that they actually are a victim of violence. This is similar language to our lease break language for a victim of violence. Number two, if there has been abandonment, if this person is no longer occupying the property, and why maybe they are not occupying the property. If the survivor knows, that's not a requirement, but again, it might provide the court with some context. And finally, that piece of non-payment, that someone has not been contributing to their obligations under the contract for a deed. This is a remedy that we are really hoping will serve a maybe smaller subsect of survivors, but certainly people who normally don't qualify for mortgages, may have difficult financial situations as is, and are just looking to preserve their property interest and make sure that they can keep moving forward. Thank you.
Thank you, Ms. Hovland. All right. Member discussion. Senator Kroon, then Senator Holmstrom.
Thank you, Mr. Chair. Happy to support this this bill and co-author the bill. I think the intentions are good on this bill. Co-vendee interests on contract for deeds are a problem, generally speaking, even outside of this realm. And so if any kids are watching at home, don't enter into a contract for deed with somebody you're not married to. Not a good idea. Many bad things can happen, but it does happen every day. So I think this is a good way to resolve some of these issues that come up for survivors of domestic abuse. So with that said, I'll just offer the A6 and then I'll explain that.
All right, members, the A6 is included in your packet. Senator Kroon.
Thank you, Mr. Chair. The A6 is really kind of a clarification. The original bill did require notice on the vendor, and the vendor is the person who's selling the property on a contract for deed to the buyers, which we call vendees. But it didn't say what happens if a vendor responded and showed up at court. What's the judge supposed to do with that? So this is just a clarification, which I think was the intent of the bill, that the vendor would have an opportunity to show up in court and show prejudice, and then the judge would make a determination on that. So that's really all the A6 sets out to do.
Senator Gustafson to the A6 amendment.
Thank you, Chair, and thank you, Senator Kroon, and I apologize I didn't thank you earlier for joining me on this bill. We see this as a friendly amendment.
Any further discussion on the A6 amendment? Not seeing any. All those in favor say aye. Aye. Opposed? Motion prevails. The amendment is adopted. Senator Kroon.
Thank you, Mr. Chair. I'll offer the A3, although I am going to end up withdrawing it, but just so people understand what I'm referencing, it is the A3. So I'll
It's in your
offer-
packet, members.
Yep. So when I started thinking about this, one of the concerns I had, and this is just for member discussion or for future bill ideas, I guess, but one of the concerns I had is, do we really want to be litigating and adjudicating domestic abuse within the context of a contract for deed, a real estate matter, essentially? And I heard from a number of real estate lawyers that were kind of uncomfortable with that concept. Like, this is a real estate matter. Why are we, shouldn't there be a separate proceeding for that? And so as I was working with the stakeholders here, I thought, well, why if this is a good real estate concept, why should we limit it to the victims of domestic abuse? It could be available for everybody, and that would also obviously be available to them. And so what the A3 does is kind of take that part out of it and make it a broader real estate principle. And I thought the benefit to domestic abuse victims would be that if the abuser has left the property and they've abandoned it and they're not coming back, they probably have no interest in the property, and it would likely be uncontested and go by default. Where if there's domestic abuse findings associated with the proceeding, I thought they might be more likely to contest because they may not want that finding on their record. And so I thought it would be beneficial to the victims if to not have that part in here and just make it a general real estate principle. But however, as I further was talking with the stakeholders on this, their concern was that some unintended consequences of that could be what we're talking about here today. It's the victim staying in the property, but there are also cases where the victim leaves the property. And they were worried about, if we take the domestic violence findings out of the process, that could be used against a victim who has left the property by their abuser to try to strip them of the equity. And so I acknowledge that that could happen. So even though I think this is something we should explore as just a general real estate matter, did not come up with something to protect the victims from that unintended consequences. So I said, maybe that's a future project where we can take this bill and kind of expand on it later. So that's the reason why I will now withdraw my A3 amendment.
Senator Cronin withdraws the A3 amendment. Senator Gustafson, within the context of this bill, would there have to be a finding that domestic abuse occurred in order for the remedies to be applied?
Mr. Chair, yes, that is one of the parts of the bill that is listed in my pile of papers. I could try to locate it, or you could just trust me. But yes, it is in there.
Senator Cronin cites a Ronald Reagan principle, trust but verify. Is there any kind of a way to, if there's an allegation of domestic violence has occurred, but without an actual finding that in fact domestic violence did occur, still be able to apply the remedies? I mean, I know in OFP proceedings, for example, parties to the proceeding could say, we accept the no contact restrictions, but we don't want any findings entered about what actually, you know, we disagree with the allegations of this, that, and the other thing in the petition. So they get the remedy, but without the findings. Is there any comparable provision in this bill, or could there be? Would it work?
Mr. Chair, if it's okay, I'll hand it to my testifier who's got the bill language here that might be able to answer your question.
Ms. Hovland.
Thank you, Chair. So excellent question. We modeled the formal finding of domestic abuse that a survivor needs to prove after 504B206, which are lease break statute here in Minnesota. It's also one of the only statutes I reference by name and statute because I reference it so often with victim survivors. But we essentially co-opted that language and put it in here. So it's the same as that. It includes a valid order for protection, a no contact order, a writing produced and signed by a court official saying that someone's a domestic abuse victim. You know, that could be something maybe in a criminal proceeding making that finding, but there's maybe no DANCO in effect anymore, so you wouldn't be able to use that, right? So it's trying to create these flexible opportunities for someone to show that they are a victim of violence, while also kind of making sure that they have to prove it, because again, we are concerned that this would be used as a weapon against survivors if it was opened up too much. And so that qualifying document is there. Now, in regards to an order for protection proceeding and differentiating between that and this, an order for protection proceeding, when there's a finding of domestic abuse in that kind of case, it can automatically convert over to a family court case and impact the presumptions on custody, which is the big reason that people usually agree to an order for protection without findings of domestic abuse, because then the OFP is in effect and it's kind of a compromise for the parties, right? There's protections for the survivor and there's constraints upon the alleged abusive party. However, there's no finding of domestic abuse that you can turn around and immediately apply to say there's no presumption to joint legal custody in this case anymore, or the parties don't have to attend mediation because there's been domestic abuse. Now, in a family court proceeding, a court can still make those findings based on evidence of domestic abuse, right? But there's not that technical check mark there. In this proceeding, it's a little bit different because this wouldn't necessarily automatically open a finding of domestic abuse that you could use in a custody proceeding in the same way, right? It's a different kind of tie. It's much more similar, again, to 504B206. And additionally, I mean, you could challenge the validity of the qualifying document, right? You could say that's not a valid order for protection. It doesn't exist. You made that up with AI, right? You could try to figure out that way. But if it is a valid qualifying document, then the other person would really only be able to challenge the status of either the non-payment or the abandonment. So I don't think that we're going to get into an issue of litigating extensive domestic abuse in this proceeding. I think that court document kind of makes that finding unless that document is inappropriate, and then it gives discretion to the court to address those other two staples of this piece. I do think in terms of the court's powers of equity and justice, they could come up with that remedy and say, hey, we're all here today. We have an issue, contract for deed. I have this in front of me. You know, would you agree just to allow this to go into effect? I can issue an order saying the parties agree that this interest would be severed and terminated, et cetera, et cetera. But that would be more in the court's equitable powers. I think building that in, similar to our order for protection proceeding, might make this a very difficult, burdensome bill for a survivor to actually use.
So, Ms. Hovland, I suspect in an OFB, I haven't read the statute closely in a while. I suspect the statute doesn't actually itemize the option of a OFP without findings. or maybe you can correct me if I'm wrong, does it actually itemize that as an option, or does the court just tend to do that on its own if they?
It does, Chair.
it
Thanks for that clarification. It provides that, and that's the advice I tell survivors every day on our action line. I say there's going to be an admit-deny hearing. The burden is on them to admit or deny to the charges. They can admit two ways. They can say, I've done the abuse and I agree to the order. I can personally say, in all my years of practice, I have never seen someone agree to that admit provision. The second is admit without findings, which is much more common, and then the third is deny. Most judges should go on the record and explain that to individuals when they don't have representation, and good judges do. So that is built into the order for protection statute.
Okay. And then in the bill before us, you've identified a number of documents that would serve as the proof of domestic violence having occurred. In the absence of those documents, is there a proceeding provided for in the bill before us for there to be a separate hearing conducted by the court to determine whether or not domestic abuse or violence occurred? Or is it solely the documents from other locations that would support the claim?
It is solely the documents. Those documents can come from one of those proceedings. So the valid order for protection or the no contact order, for example, a DANCO, those would be findings in a separate proceeding that could be used here. You could just turn in your order for protection. That would be a qualifying document. But there's also a lot of flexible ways that survivors could try to get documentation of this, but also consult with professionals in that arena. And so it includes someone who is a third party who works either as a sexual assault counselor or domestic abuse advocate. They can provide qualifying documentation, but again, that language is co-opted and mirrored from 504B206. So great question.
Can you point me to the language in the bill that you're referring to?
Certainly. So it is on page 1. Qualifying document starts at 2.1 and continues down to 2.12 on the second page.
So under the provision, the bill that's before us, in the absence of any qualifying document, would a civil judge hearing this proceeding have the ability to have a full-blown evidentiary hearing as to whether or not domestic abuse occurred?
I don't believe so under this bill. That would be appropriate. Again, if the survivor needs to find a qualifying document, there are ways to do so. Local advocates at domestic abuse shelters can provide these documents and frequently do for lease breaks. So there are kind of flexible arenas where someone could go if they were fearful of trying to get an order for protection and retaliation, or were fearful of criminal charges that might result in a DANCO. So I don't think that this would allow that judge in this specific proceeding to open it up and say, can I make this finding on my own? I do think, though, that the survivor has flexible options to provide that qualifying documentation.
And then any challenge would be to collaterally challenge the qualifying document's authenticity or accuracy, is that right?
Exactly. And with a qualifying third-party statement, obviously that's going to be remarkably difficult because the domestic abuse advocate has confidentiality under our current laws. But if you could show, again, that if there's some legitimate reason that this is not a proper qualifying document, this is not a legitimate document, it's not been signed by the right person, it's, hallucinated by AI, whatever the means, that would be a means of challenging it. But if they were just trying to challenge that domestic abuse has occurred, that would not be appropriate, and they would need to focus their efforts on either determining that abandonment has not occurred or that non-payment has not occurred if that qualifying document is deemed an appropriate upheld document.
As in an authentic document?
Exactly. Essentially, it would be authenticated by either the sworn written certification from a third party, it would be authenticated by the court having a proceeding on domestic abuse previously. That would be the only challenge you would be able to make about the qualifying document is it a valid and authentic document purporting to be a domestic abuse document.
So theoretically, forgive my questions, I'm just trying to wrap my arms around this. Theoretically, a person seeking the remedies in this proposal if they can get one of these qualifying documents signed by the person who would make it a qualifying document, there really isn't any mechanism by which that person, they could challenge the underlying accuracy of the allegations contained in the document, correct?
You are correct.
So I'm not suggesting this would happen ever or frequently, but theoretically, you could have someone fabricate allegations, put it in a document, sign it as provided in this bill, submit it in this legal proceeding, and there'd be no way the other party could challenge the validity or accuracy or truthfulness of the underlying allegations. Just a question, did so-and-so sign this document, and is it a real document? Am I missing something here?
It's a little different than that. So in the 504B206 process, these are all requisite documents where a person cannot just get them on their own, right? They have to ask a court official, they have to ask law enforcement, or they have to ask someone who's either a domestic abuse advocate or sexual assault advocate. Working in the domestic and sexual violence field, I can tell you that we get a lot of inquiries from abusive parties who have been violent to partners who are trying to weaponize remedies for survivors against the survivor, right? They're trying to give you the right language to show, I'm alleging this person abused me, and then you look deeper into the record and you're realizing that's not true. That's not the case, and it seems like we're trying to use protections for survivors against someone who is in fact a survivor. This bill, just like our 504B bill, protects against that by either making sure it's executed by a court, law enforcement officer, or by a professional in these fields, right? So it's not as if someone could just get this documentation on their own. And then additionally, again, that non-payment and abandonment provisions, if someone is still paying for the property, that's going to be an absolute defense. You're not going to be able to be ousted through this, right, if you're still contributing financially. The same would go if you're still residing at the property. You wouldn't be able to be ousted in this way. So I understand that concern, but I think our 504B206 operates remarkably similarly. I have not seen significant issues in my practice dealing with people fabricating those documents. And when they are fabricated, I can say that it's, in my professional opinion, it's fairly easy to understand who is making an inappropriate request and holding out a document to be something that it is not.
Thank you. Senator Kroon, I kind of jumped in, wasn't sure if you were done with what you wanted to address, and if you are, we'll move on. If not, you're done? Done? Senator Westrom. No, Senator Holmstrom was next, then Senator Westrom.
I had the exact same concern, and you guys have gone much farther than I intended to, so thank you.
Senator Westrom.
Mr. Chair, I'll try to make this as succinct as possible, but first of all, I sent staff an email. I'm not getting the A6 amendment, so I'd like to know exactly what that was. So maybe I'd first just ask Senator Kroon and Senator Gustafson to kind of recap that language so we know where we're at in the bill. But my concern or questions is, Senator Gustafson, just to give you a little premise, is
Senator Westrom, staff just resent the A6 amendment, so hopefully you'll. Senator Kroon, did you want to recap anything?
From the A6, the original version of the bill required notice to the vendor. So the vendor would get served the same way and would get as a summons. So they would get notice, but it was silent on what the vendor's role was in the procedure. So what the A6 does is it just kind of makes it clear what I think the intent was, is that the vendor would have an opportunity to come into court to show prejudice, and then the court then would have the ability to deny the petition if the vendor showed prejudice. That's what the A6 was.
Senator Westrom, any follow-up?
Thank you, Mr. Chair. Senator Gustafson, that's one of my concerns or questions. Just what I think the bill is got a good purpose or functional purpose too, but I just think there's a lot of unintended consequences here that we need to really dig into a little better. But so what is your understanding of a situation where there's quite a bit of equity in the, what if there's $500,000 of equity built up in the contract for deed? And the parties have fought. 6 months seems like a long time, but it's probably not a long time if they're not on talking terms. I'm just trying to figure out how you envision this equity to be split up, or is it just that that's the consequence of having domestic abuse charges brought against you? You're out $500,000 of equity in a contract for deed, as opposed to having a judge split up the equity and say, okay, you're out, you're divided, but the party still owes you $500,000 of equity when the property's sold or buys it out from you? Or what do you do in those situations where there is a lot of equity? Because
Senator Gustafson.
Thank you, Mr. Chair. We have, I think, at least two people who are eager to answer this question. We have another testifier, and then I don't want to speak, but I think one of the senators on the committee would also like to respond. So if you're so inclined.
Just members, so you know, apparently this room was assigned to some other use at 3 o'clock. We've been informed that, so we're on limited oxygen right now. So we'll just kind of focus in on the questions and we'll wrap up. Mr. Elwood, to that question.
Mr. Chair and Senator Westland, if a contract for deed vendee doesn't pay, under the current law, within 60 or 90 days, the contract could be canceled and they would lose 100% of all the equity that they put into it. That's the way the law works. And so in this situation, it's the same thing. The abuser has abandoned the property, has not paid for 6 months. If the abuser was the sole vendee, they'd be out completely. Plus, second of all, under the bill, the abuser has every opportunity to come to court and make a claim, and that issue then of division of equity under the court's equitable powers would be adjudicated. And if the court felt that there was some compensation required, then that would be a judicial decision. If they thought not, then it's the judge's call. So this really doesn't change current law. That abuser would have lost 100% of every cent that they put in for 10 years if they didn't pay, and this person hasn't paid for 6 months under the bill.
And Mr. Chair, Mr. Elwood, I mean, that potentially makes sense in a situation where you don't have these hard feelings going on between the parties. That brings in a whole new dynamic. But it doesn't look to me in the legislation that it really is clear to the courts that they may offer an equitable remedy. It just says you divide their interest. If these points are met, they're out of their real estate interest. And so I don't see that as clear that the courts can offer an equitable remedy if that's what they raise as part of their defense. Secondly, let me jump to the vendor. What is in it? How does a vendor stop this split if the party that's being extinguished has the income or the assets that was relied upon when they went into the contract agreement in the first place? Because that is it's usually both parties that bring something to the table. And now, if they're going to extinguish one of those sides, I think there's a lot of concerns for the vendor's interest, especially if they're going to take a risk in the beginning to sell to two non-related or non-married parties. How is that going to get handled in the court in your view of it?
So members, we got 2 or 3 minutes. If we don't wrap up, we're going to lay the bill over. I'd rather not, so I'm not sure I want to keep our discussion focused on the specific bill that's proposed. rather than a more general question about how the law operates. So Senator Westrom, was your question relating to the specific proposal and how that might play out in court, or is it more general to the
No,
existing
exactly,
law?
that's my question.
All right,
Mr. Chair.
Senator Kroon, did you indicate you wanted to respond to this, or shall I have Mr. Elwood?
The first issue on the respondent, not the vendor.
Okay, Mr. Elwood, to the vendor question, briefly, please.
Mr. Chair, Senator Westrom, the vendor has two options in a situation. First of all, it provides, Senator Kroon's amendment provided the opportunity for the vendor to be able to demonstrate prejudice. So the prejudice, that's what goes directly to your question. The vendor has two remedies if there's no payment. One is to sue for performance. Two is to cancel the contract. In residential contracts for deed, nobody, no vendor ever sues for performance. The remedy is cancellation. And in this case, the whole point of this is the survivor is making 100% of the payments, has made 100% of the payments, and wants to continue to make 100% of the payments. If they don't, the remedy is this, under current law. Then they would get canceled in 60 or 90 days, depending on the status of the seller.
Senator Kroon, to the first question from Senator Westrom.
Thank you, Mr. Chair, and I'll be brief. Mr. Elwood covered most of it. I would say that the bill would assume that the respondent is not making any payments for the last 6 months, but I remembered that the bill doesn't specifically say that. That was tied up in my A3 amendment. It just says, the bill just says that the respondent has ceased to occupy the property and that the petitioner has made all the payments. I think an oral amendment that would say the respondent has not made any payments due on the contract for deed would get at Senator Westrom's concern. And that would go on line 4.28 after contract for deed. So it would read, the respondent has ceased to physically occupy the property that is subject to the contract for deed and has not made any payments due on the contract for deed for the 6 consecutive months preceding the service of the summons.
Mr. Elwood, to that proposal.
Senator Latz and Senator Kroon, the irony is the original bill before the amendment actually had exactly that language, and we took the amendment from the Bar Association, which changed it to the current language, which now you want to change back to the original language. So it's up to the author.
Senator Gustafson, you're caught between the Bar Association.
Yeah, association I do not belong to.
The advocates and Senator Kroon.
Yes, it was in the original bill. I would accept that oral amendment as a friendly amendment, especially for the sake of time as well.
Did I hear the Bar Association doesn't like that language?
Mr. Elwood.
Mr. Chair, Senator Kroon, we originally had it that the abuser didn't make any payments, and they changed it to the victim made 100% of the payments. And so we've been trying to work with the Bar Association. They've been wonderful. They've created, provided tremendous amount of technical help. And so we just adopted what they said. So it's up to you.
Mr. Chair,
Senator Kroon.
far be it to me to disagree with the Bar Association. I don't want to do that. But it seems to me that adding this is beneficial. It protects the respondent's rights because even if the petitioner is making all of the payments, the respondent could be trying to make payments, could be making payments to the petitioner. And with my language in there, they would have a really good defense if they were trying to make payments, but the petitioner wasn't accepting them. Whereas if it's left the way it is, it's a little bit unclear. So
Senator Kroon, could you restate your proposed amendment?
4.28 after deed, insert, and has not made any payments due on the contract for deed, comma, and then it goes back in for the 6 consecutive months preceding the service of the summons.
Ms. Primo, do you have that?
Just one more thing, sorry, and has not.
Senator Kroon.
And has not made any payments due on the contract for deed.
Ms. Primo.
Mr. Chair and members, I believe then that same amendment would have to be made in at least 2 other places in the A2. So I think if it gets adopted, just the technical
Mr. Chair.
authority to make that change.
Senator Cronin.
How about I work with the Bar Association and the stakeholders, and if everybody's agreeable, I could make it as a friendly amendment on the floor. Otherwise, I'll just drop it.
Senator Gustafson, that okay with you?
That works great.
Okay, this will be a rare occasion in which I think we let it get fixed on the floor. If the people involved can do that. Senator Westrom, we're about to kick you out of the room here.
Then let's lay the bill over, Mr. Chair.
What is it, Senator Westrom, please?
No, Mr. Chair, I just think there are more issues here, Senator Gustafson. I think you got a good start with that time limitation we have here. Senator Kroon has pointed out a point here. I would like to continue to work with you as we get to the floor, because I think there's a lot of unintended consequences or concerns that are scenarios we haven't even thought about necessarily here. And that's what I'd like to just make sure we've
Mr. Chair, thank you, Senator Westrom.
Gustafson.
I think the plan was to move this forward. I'd still like to do that. I'm happy to work with Senator Westrom if he thinks there's additional things, but I really think that we've got it locked down between the Bar Association, all the stakeholders, Senator Kroon being a co-author. I think we're ready to move forward.
All right, Senator Gustafson will follow the wishes of the chief author there. Senator Oumou Verbeten moves that Senate File 3907 as amended be recommended to pass and be referred to the Senate floor, and council may make any technical corrections as needed to reflect the work of the committee. All those in favor say aye. Aye. Opposed? No. The motion prevails. Members, we are going to see you tomorrow morning, 9 o'clock, Minnesota Senate Building, room 1200. The participation will be available by remote as well. Members, we're not adjourned yet. Did you all hear the announcement? Tomorrow morning, 9 o'clock, room 1200, available by remote if you can't be here in person. And plan on a long day. We expect to take a break between 5:30 and 7:30, and then return to complete any portion of the agenda that's not done by 5:30. Thank you. We are adjourned.